traffic.
Somebody should fix that.
Yes.
When we
Yeah.
went all virtual, I'm like, ooh, this is gonna be different.
Did you get it all worked out with whoever's coming in your district?
I'd like to call the meeting to order, please. We stand for a moment of silence in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, Madam Clerk, if you want to have the roll call, please.
Mr. Jamie Girardi, Mr. Don Anderson, Mr. Peter Hansel,
Here.
Mr. Jonathan Moody,
Here.
Mr. Christopher Poole,
Here.
Mr. Chris Williams,
Here.
and Chairman Charles Gray.
Here. And proof of publication, please.
The items were published in the Tampa Bay Times on August 17th, 2022, October 5th, 2022, October 9th, 2022, or by certified mailings and site postings.
All right, thank you. And I don't believe we have any minutes. Okay, well, I'd like to welcome everybody today. We're the Planning Commission. We're appointed by the Board of County Commissioners, and we meet twice monthly. We serve as a local planning agency, and we hold public hearings and transmit to the Board of County Commissioners recommendations on comprehensive plan amendments, land development code amendments, rezonings, and conditional use requests. Planning Commission is the final decision-making body for special exceptions, certain appeals, variance requests. However, final decisions may be appealed to the Board of County Commissioners. If anyone is in opposition to any development code amendment, rezoning, conditional use, or any item where the Planning Commission transmits a recommendation to the Board of County Commissioners, it's important for you to attend the appropriate Board of County Commission meeting. For those of you who are not familiar with the format of the meeting, we have 3 segments. We have continuances. Those are where the staff or the applicant have requested a continuance for any number of reasons. It's our tradition to approve those continuances unless there are extenuating circumstances. Then we have consent, and those are items that we've not received any objection from the staff or from the public, and we'll go through those items one by one. If there's something on the consent agenda that you want heard, please raise your hand, and we'll pull it off for consideration and put it on with the regular items. That's the 3rd section. Those will be fully vetted. Applicants will have 3 minutes to make their presentation, and questioners will have 3 minutes to respond, to ask their questions, and then the applicant will have a chance to come back in and answer those questions. We also have an opportunity for anybody who's given us a written request 24 hours prior to the meeting for additional time. I don't think we have any. Is that correct?
That's correct, Mr. Chairman.
Okay. So this is the time when I would ask you to, if you have a cell phone, I'm sure most of you do, please put it on the silent position. Before we start the regular meeting, we're opening the meeting for public comment on any items that are not on today's agenda. If there's someone here to speak on something that's not on today's agenda, this would be your opportunity to come up and speak. Is anybody here for that purpose? See no one?
Mr. Chair, just for the record, we did have someone who had signed up to speak for public comment on WebEx, but that person is not online.
Okay, thank you very much. So if you plan to give testimony, or if you plan to come up and speak today, if you would please stand, raise your right hand, and be sworn. Anyone who plans to speak or may speak.
Do you swear or affirm the testimony you're about to give is the truth, so help you God?
I do.
Okay. All right, with that, I guess we can start.
Good afternoon, Planning Commission members. Denise Hernandez, Planning and Development. First item is PC1. It's a PDD 23 CU05. It's a conditional use for a wireless communications facility. I did send a modified agenda memo on this. The applicant very late yesterday afternoon requested a continuance to December 8th, 2022. It's actually a staff requested continuance, I apologize. Planning Commission meeting at 1:30 in Dade City.
All right, so we have a request for continuance on PC1. Do I have a motion?
So moved.
And a second?
Second?
A motion and a second. Any further discussion of the motion?
I just have one quick question. You know that's going to impact the community I live in. Are they going to be notified of this continuance? And if so, how?
Typically, that's not the case that we notify of the continuance, but I will say that we have been in contact with several folks in the community, and they are actually aware of the continuance request to 12/8 Planning Commission, the request for continuance to that date.
Okay. If I am contacted, I don't think I should have a problem with that. I will have to fill out the proper documentation that I have been contacted. True.
Contacted by the applicant, yes.
And
Unless you're
residents.
contacted by the applicant as and David, please jump in, but you could be contacted by the applicant as a member of the community, because I believe you're on the CDD board, is that?
I was up until recently.
Okay.
So,
If you're being contacted as a member of the planning commission, whether it's from the applicant or the objectors, yes, you need to disclose those communications.
okay, thank you.
If they're by email, you just forward them to Denise like you normally do.
Okay, thank you. Appreciate that.
Okay, we have a motion and a second. Any further discussion? If not, all in favor, signify by saying aye.
Aye.
Opposed, like sign? Okay, motion
Item
carries.
Item PC2 is PDD 23 CU03. It's conditional use in the name of Home Elite LLC and Priya Properties for multiple family dwellings in a C2. The applicant has requested a continuance to the January 19th, 2023 Planning Commission meeting at 1:30 in Newport Richey.
All right. The applicant present? Okay, anyone here to object? Do I hear a motion?
So moved?
Second?
Motion and a second. Any further discussion? All in favor, signify by saying aye.
Aye.
Opposed, like sign? That's continued to the same date, 12/8.
That would be 1/19/23 Planning Commission meeting at 1:30 in Newport Richey. 19/23.
Thank you.
You're welcome. The next item is PC3 PDD 230013. It's a large-scale comprehensive plan amendment, CPAL 2213 for Hamilton Elks. The request is to continue the item to the November 3rd, 2022 Planning Commission meeting at 1:30 in Dade City.
November 2020.
November 3rd, 2022,
Okay.
1:30 Dade City.
All right. Is the applicant present? Anyone here to object? See no objections? Hear a motion?
Move
So
to
moved.
continue.
You have a motion and a second.
Second.
All in favor, signify by saying aye.
Aye.
Opposed, like sign? Okay.
PC4 is PDD 232099. It's a variance request in the name of SDG South Acquisition LLC, DR Horton, Willow Reserve. It's for an increase in the maximum lot coverage from 45% principal structure and 20% accessory structure to 65% total lot coverage combined for all principal and accessory structures for lots 6, 7, 11, 27, 30, 31, 34 through 36, 41, 42, 49, 55, 56, 58, and 60 of the Willow Reserve subdivision located in an R4 high-density district. It's on the north side of Collier Parkway, County Line Road, approximately 500 feet west of Livingston Road. Comes to you with a recommendation of approval with conditions as contained in your agenda packet.
All right, this is on consent. Is the applicant present? Okay. Anyone here to object? Okay. Next.
Following is in your addendum, APC 5. It's PDD 237659, special exception in the names of Rosa E. Ibrahim, front door duplex. Special exception for a duplex in an R4 high-density residential district. Comes to you with a recommendation of approval with conditions as included in your agenda packet.
All right, is the applicant present? All right, anyone here to object? This is a consent item, okay?
Yes, and the next item is the last item on your consent agenda.
Okay,
It is APC 6, Small Scale Comprehensive Plan Amendment, CPAS 2216, Decubulus and Little. It's for a small scale comprehensive plan amendment to the future land use map 2-15 and sheet 18, changing from Res 3, residential 3 dwelling units per gross acre, to Res 24, residential 24 dwelling units per gross acre on approximately 13.36 acres located on the south side of Decubulus Road, approximately 600 feet east of Little Road and Decubulus Road intersection. And it comes to you with a recommendation. On this item, you're actually sitting as a local planning agency, and we're asking that you find it consistent with the comprehensive plan and recommend approval to the Board of County Commissioners.
okay. Is the applicant present? Anyone here to object? No objections? You have a motion?
Move to approve the consent agenda?
Second.
You have a motion and a second. Any further discussion? All in favor signify by saying aye.
Aye.
Opposed, like sign? Okay,
All right, the last item on your agenda is APC 7. It's PDD 230017. And while my colleagues bring up that PowerPoint, I will tell you that this is LDC Amendment 61. This is the set of package amendments that have been worked on through the ordinance development team as a result of different things. Some things have to do with implementation, other things have to do with board direction, and you'll see some Scrivener's errors in there. And then you'll also see things that were requested by the Tampa Bay Builders Association or by the industry. So these proposed amendments were presented to the horizontal roundtable. Actually, one of the amendments, when we get to it in 802, that was presented to the horizontal roundtable on June 15th, 2022. I presented the amendments to a subgroup of the horizontal roundtable on October 12th, 2022, and again yesterday on October 19th, 2022, to the horizontal roundtable at their regularly scheduled meeting. So we're going to go through the list of the different items that are included in your agenda packet of the changes that are being proposed, and I'll tell you where where they originated from for the most part. So the first item that's being changed is amended is Chapter 300, Section 304, Public Notice Procedures, and it's the table in 304.1, required public notices for development application approvals. This basically adds a row in that table for comprehensive plan amendments to be mailed, published, and posted. This is from the direction of the Planning Commission and from the Board of County Commissioners. The next change is Chapter 300 Procedures, Section 304.2C, Public Notice Published. This is basically in anticipation of Section 50.011 Florida statutes, which basically allows publication on publicly available websites. So we're just adding the words by any other means. So newspaper publications are kind of going by the wayside. So beginning January 1st, 2023, I believe that's when the actual effective date of that statute is. We'll be able to do them by publishing them in a publicly available website. And I think there's some folks that are working on that process for the county as we speak.
okay.
So the following section is Chapter 400, Permit Types and Applications, Section 402.2B, Zoning Amendments and PUD. This basically clarifies that projects that exceed the capacity of 1,200 daily trips are as shown on Table 402.2-A. So this is going to be a little bit clearer when I tell you that 9015 traffic impact study is being stricken, and that's where that 1,200 daily trip table resides. So that table is now being moved to 402.2 because it calls out 1,200 daily trips. So how do you know what projects exceed the 1,200 daily trips unless you have a table? So we're including the table in there. I do want to say that we will be discussing probably within the next few months and into 2023 about is that really an appropriate threshold, 1,200 daily trips. So that's something we're going to be talking about. Additionally, to kind of lessen the number potentially of MPUDs that are coming through, we're including that projects that are subject to a development agreement, special exception, or conditional use do not require an MPUD. So the following section that's being modified is Chapter 400 Permit Types and Applications, Section 403.3 F1 Preliminary Site Plans, Time Limit on Approval. That section now has language that if the building permits expire after the 6th year of the PSP's approval, the PSP also expires. This next item touches several sections, which is just basically replacing the term permit with placard. So in other words, it's now no longer a hard copy site development permit, it's a hard copy site development placard. That's called out in 4034 Stormwater Management Plan and Report, 4035 Construction Plan, 4037 Mass Grading, 40310 Landscape Plan, and in 522 Connected City MPUD. The following section is, I do want to say that there is a typo on your memo. I just realized that either earlier today or yesterday. Instead of saying non-substantial, it says consubstantial modification. I apologize. So it's basically removing the statement that only portions of development affected by the substantial modification are subject to additional review. Well, a substantial modification is basically, you look at the entire thing. Only those, so that section is being moved to non-substantial. So it should be only portions of the development affected by the non-substantial modification are subject to additional review. So the next section is, I need to talk about definitions before we get into the section. So this is something that, kind of like the genesis of this was through Planning Commission. If you remember last year, we had an alternative relief. I believe it was in December, and it probably got continued into January, from a firm called EYS regarding conditional uses and the definition of a family and those type of things. So this kind of, hopefully, we think, will fix all those issues. So basically, our definition of a family, if you see that up there, it was basically an unlimited number of people. It just says it could be a single person, 2 or more persons, whether related by whether or not related by blood marriage or adoption. So this definition is directly from Manatee County. David worked very hard on this. I was just, in the background on this one. And he did a great job, and we did speak to and work with the I forgot the type of law that he does. Mr.
Fair Housing
McDonald.
Act attorney.
Say that again?
It was the Fair Housing Act.
Fair Housing
attorney,
Act.
yes.
Yeah, Fair Housing Act law, and this is the result of that. We also changed the definition. Now the concept is called a group living arrangement.
So Denise, if you could just go back to the
Yeah,
prior
sure.
one, just to be
Absolutely.
clear. So the reason that this definition is important is because this is the only type of family that can reside in a single-family dwelling. That's the reason so you need to understand the definition in the context of zoning, which is that in single-family neighborhoods, only if you fall within this definition are you considered a family. If you don't fall within this definition, you're going to be something else, which Denise is about to cover in the next definition.
Okay.
Okay.
Right, so if you don't fall into that, then you're basically a group living arrangement. And it explains, what a group living arrangement could be. It could be a boarding home, it could be a fraternity, it could be a convent. It's not limited to these things, but these are some ideas of what a group living arrangement is. And the following definition that was modified is the definition of a residential treatment and care facility. Because a residential treatment and care facility is really more of a facility that employs the services of skilled and licensed health practitioners. So we wanted to make sure that that was what stood out in that definition, certainly. All right, so how is this in the LDC now? So residential treatment and care facility, and this is no change to the land development code. They continue to be permitted uses in C1, C2, C3, I1, and I2. No change, that's still the same. It's now also no change is they continue to be conditional uses in AR, AR1, R1MH, R2MH, R1, R2, R3, and R4. This is the change with residential treatment and care facilities. It's now a conditional use in AC. It was previously a permitted use in AC. Now a conditional use not mentioned in AC1, but now a conditional use in AC1, AR5, AR5MH, ER, and ER2. Group living arrangements, this is all changed to the LDC. Permitted use in MF1, MF2, MF3. Conditional uses in AC, AC1, AR, AR1, AR5MH, AR5, ER, ER2, R1, R1MH, R2MH, R2, R3, and R4.
Can I ask a quick question?
Sure.
Was this change brought about by the occurrence of the group home in
Yes.
the Quay
Yes.
Hollow area?
Yes.
Okay.
And so if that home came in after these code amendments were adopted, it would clearly be a group living arrangement because they were requesting more than 6 unrelated individuals, which this clearly says that's a conditional use in the residential zoning districts. So the issue we had in that, with that particular facility was our code had not been amended with these requirements, so it allowed them to have the argument that you could have an unlimited number, because of our definition of family, you could have an unlimited number of unrelated people living in a single-family home.
So,
This clearly limits it to no more than 6.
so this, if that would have come before the board with this wording here, that would have been a
A
negative?
conditional use application. They would have had to submit a conditional use application. If you recall, that particular project was asserting they didn't have to because it would violate the Fair Housing Act. Now, we ended up imposing conditions on them through the alternative relief process, so we may have got to effectively the same result, but this makes it perfectly clear that staff's original position was that facility needed a conditional use. It wasn't until we got the Fair Housing Act complaint that we had to reevaluate the issue. But I think at the time, Planning Commission told us, you need to go fix your code.
Right.
It shouldn't happen again. That's what Denise is doing. Now, you could still have up to 6 unrelated people, but, and that's how many codes are drafted, is that you get up to 6. This definition of family says you can have up to 6 unrelated, or you can have, I think, 2 related and then up to 4 unrelated, or an unlimited number of related.
One of my main concerns with that was the terminology for skilled and licensing staff. And if you recall, it was brought to our attention that some of the staff, you had a very broad definition of skilled or licensed, because the number of people that were really there as in a custodial fashion, in other words, they were going to monitor the movements of the residents from point A to point B to ensure that they did not go beyond the boundaries of the property.
So I think under these revised definitions, that facility either would have been a group living arrangement or a residential treatment and care facility, depending on the level of skilled care.
Yeah.
So, but regardless, under either scenario, it would have been a conditional use.
Yes, both of those are listed as conditional uses in that district.
Just out of curiosity, David, how is the definition of family, Denise, if you could flip back to that, is that pretty consistent with other codes in the states?
Yeah, in fact, it's
This is from
listed,
Manatee
it's
County.
identical
Oh, it's
from the
from
Manatee
Manatee?
County Code.
Okay.
Yes.
Well, I got a question about that. So, if I'm reading this right, if you're a natural family, it doesn't matter, you can have 1,000 people in a house.
Well,
Can be
yes,
pretty prolific.
the Florida Building Code, the Florida Building Code has some occupancy limits on a home that would come into play. But from a zoning perspective, yes, you're correct. In other words, the Florida Building Code requires that you have a certain amount of space per occupant to comply with the Florida Building Code for fire safety reasons and other reasons. So, but if you're asking from a zoning perspective,
Does the building department go around and enforce them? That's something new
well,
to
so
me.
the answer is actually yes, because that was an issue with elevated use services, was that part of the reason they weren't able to expand too much beyond 6, or why they were having difficulty expanding beyond 6, wasn't necessarily because of zoning, it was because they were having a hard time meeting the Florida Building Code requirements for occupancy.
So the question I have about the definition, marriage and adoption are very clear to me, but what is blood? We live in an age where I can go get a 23andMe test kit and in a few weeks, I'm gonna get something back that says I'm related to the Prince of Wales or something, you know, and then is he my
You
family,
wish.
is he my blood? Well, another question came up in my own family. My father's brother got divorced. So is his first wife still my aunt?
Father's brother
That's a tricky one.
Yeah, so that'd be an uncle
So
and an
when I
aunt,
was,
and she's
when I
still
was
your aunt.
born, they were
Yeah.
married, so he was my uncle and she was my aunt. But then they got divorced, oh, I don't know, 5, 6 years ago. Is she still my aunt?
I think if you're no longer
Is
related.
she my
to-
family?
If you're no longer related to that person by marriage, and it sounds like you wouldn't be, or blood, it sounds like you wouldn't be, I would guess my answer would be no, you're not. Now, they still may be able to live with you because of B and C.
Well, I understand it's when you get over the 6 people that creates the concern, and I'm not opposed to the 6-person cap. What I'm getting at is that someone could really stretch this definition as to what constitutes blood. Is your second cousin, 5th cousin, 45th cousin your blood?
Well, I can tell you that historically, we haven't had an issue with that. I
think what I'm getting at is if you're saying that there are occupancy limits defined by the Florida Building Code, isn't that more definite rather than trying to get into who's who and who's related or not related, and so long as you don't exceed those occupancy limits,
The
would
problem
you be
is
good?
that this is a zoning restriction. The building code is depending on the size of the home, and so you could have a very, very large home in a single-family district that can accommodate way more people than a small home. So the definition of family has to be flexible enough to deal, and for zoning perspective, has to be flexible enough to deal with all of those scenarios. So this is saying
Right, I think where
regardless
we
of the
run
size of
into
your
We
home,
would probably run into a problem is if we have 50 people in a 2-bedroom home. It's not if we have 50 people in the 15-bedroom mansion.
I understand, but this is still saying that, because remember, we're talking about what is appropriate in a single-family neighborhood. So you have to decide what is a family when you say single-family neighborhood. So I don't think that even if it was a big home, if it had 50 unrelated people, that's probably not a family. That's a frat house or a sorority or something. I mean, it's
And
not.
what I'm getting at is that they may claim they're related. When you say by blood, that's not a precise definition of what constitutes relation in a family. And I will tell you, I don't object to this, but I think you're potentially opening yourself up for people to come in here and make all kinds of crazy claims as to how they're related. I used to live in River Crossing, and when you turned onto my street, the very first house on the right was owned by, well, I'm not quite sure who owned it, but they were an Asian group, and what we noticed was every other few weeks, the group of occupants in this house would turn over, and what they were labor for the Chinese restaurant next to the Publix, adjacent to the neighborhood. And could they claim they're all family? How would you ever, if they claim they
So
were,
I
how could you
don't,
prove
I mean,
they
we can
weren't?
look in to see if there's a way to constrain who's related by blood. I think the intent is,
I understand your intent.
I mean, you have to remember that our existing code said that already, by blood, and the Manatee County code says it by blood. I mean, we can look in to see if there's some jurisdiction that have defined what it means to be related by blood.
Yeah, I can see the point there, because with DNA testing, and I'm sure we've seen news people, if I go down or someone goes down to have a test, and that DNA can all of a sudden bring forward a number of people that you really don't know that well. I can see the science of today and of the future could backfire with the blood concept. That, I don't
Yeah, if
have,
we were talking 25 years ago, I don't think this would be a question.
No, but-
It's just the
but,
day and age we live in.
you know,
And from a legal perspective, I don't see how you could eliminate blood from that definition.
No, you can't eliminate blood because clearly if somebody is your father, son, daughter, brother,
Yeah,
sister.
I'm not sure if that's what's being suggested, but, you know, to constrain that,
no, I'm not arguing the point to eliminate it.
No,
I'm just saying that
agreed.
it's opening up Pandora's box because of the science
Yeah.
You could
that's
make
available.
claims that people 45 generations down, they're my blood.
Yeah, somebody
There
knocks
may
it-
be a way, I mean, I think the intent is sort of like grandparents, cousins, you know, we can figure out if there's some way to constrain the number of cousins, you know,
Yeah.
you don't want, I understand your point.
define the term blood, here's what it means, you know, uncles, aunts, and then cut it off at a certain point.
Right.
So Denise,
It's just,
is there
yeah,
some,
it's a valid point. It is.
so.
Second cousins.
Yeah, I don't know where to draw that line.
I don't know that we've encountered a code that, maybe because all codes are older, I don't know, that deals with that level of distinction of what is blood related, so, but we'll have to figure out if we can create something.
The only thing we could do probably would be limited by the number of generations.
That's an interesting concept, sure.
Yeah.
Well, but even if you limit it by generations, then you have to figure out how many cousins, you know, is the seventh cousin,
I will tell you, this is so much better than what we have now, because now it's like unlimited. You could
Yeah, I
claim
mean-
anybody as
yeah, I mean, that's.
your family.
Yes, right now, remember, go back to what our code reads today. You could have 100 people in a single-family home unrelated. That's what we're dealing with currently.
And I agree
Yeah.
that you're trying to limit it, I'm just not sure, and again, you're the lawyer here, that the word blood gets the limitation you're trying to achieve.
So, yeah, we'll look into see if there's a way to define what is,
Fair enough.
how far up and sideways on the chain of relatives you can be to be considered blood-related.
Well, all you have to do is get the winning lottery ticket, and I'm sure you'll find all the family you never knew you had.
Come out of the woodwork, yeah.
So Denise, between Denise and I, we could probably research that between the
Yeah.
time this goes to the board and see if we can define what is blood-related.
Absolutely. All right, so moving on, this next section is, this came about because a lot of, and particularly also newer staff members say to me, hey, they've got to have a park in accordance with 905.1. Is that considered a private park and they have to have a special exception? I'm like, no, that's considered an accessory use. So now we're clarifying in R1MH, R2MH, R1, R2, R3, R4, MF1, MF2, and MF3, that neighborhood parks required by 905.1 are accessory uses.
Can I ask a question about that?
Absolutely.
Okay. So is there any siting requirement for the park that would, or is there any buffering requirement for these parks?
We do have Mr. Tippin on here, and I believe we probably have someone from Parks and Natural Resources on the,
Because where I'm going,
WebEx.
I'll just get right to the question that I have is by making them an accessory use, some of these facilities may have swimming pools, they may have clubhouses, they may have.
that's an
other
amenity center. That's a little different. That is called out specifically as a special exception use. That's an amenity center.
And our code doesn't require the construction of an amenity center.
Right.
What, I think what Denise is saying is if,
All right, let me simplify it, a
Sure.
gazebo.
the code doesn't require the construction of a gazebo either.
And let me finish the question.
Oh, okay.
What I'm getting at is those become accessory structures. And then the accessory structures are only required to be set back from their side and rear property
5 feet.
lines by 5 feet. My concern being, say we have a situation where the developer opts to place the neighborhood park and it backs up to Mr. Hansel's backyard, and now all of a sudden he has the accessory structure 5 feet from his rear property line.
Are accessory structures permitted in a park like that? Or is that only for residents?
Well, I think what David was saying, it doesn't require the construction, it doesn't mean that they
But they
wouldn't
could.
construct it. They could, right?
I guess the question that Mr. Moody's asking is,
So like if they can they put a pool in a neighborhood
are
park?
accessory structures subject to setback requirements?
Accessory structures are subject to setback requirements, and Mr. Moody stated what the setback is, it's a 5-foot setback.
So you're concerned that that's,
My concern is that you create a neighborhood park, and for instance, the building code exempts swing sets on a residential property, but not a public playground, and then we cite the jungle gym and the slide and the swing sets right next to Mr. Hansel's backyard, because that's where the developer opted to put the neighborhood park, and maybe he doesn't want all the screaming children in his back.
So I'm gonna ask a question that's for my team that's behind me, because this is standard practice. This is how things work today. I'm just codifying it into the code. Have we ever had this as a problem in the past?
Hopefully not, and I don't want it to be.
I'm just, it's just,
yeah.
it's basically codifying a determination.
well,
That's what
So
we're
I'm-
doing.
can I just add before you speak, Brad? I'm not sure this change in the code affects the issue you're concerned about, because it's saying,
And that's actually, you're good, because that's the root of my question, is does this change the status? Does this make something now, a structure associated one of these parks, an accessory structure that would have some reduced setback that it otherwise would not?
I don't, tell me if I'm wrong, stuff, I don't think it is. It's just saying that it doesn't need to go through special exception approval
For a private park.
for a private park. The theory being if our code's requiring them to put in this park,
Yeah, and I agree.
you shouldn't have to go
Shouldn't
through a
have to.
special exception approval to get that approval.
Right.
Your issue is, once how that park is constructed and whether it's meeting setback requirements. I don't think this is necessarily changing the
Okay,
setback
that's what I-
requirements, but
that's,
I'll defer
I
to
think,
staff.
the real root of my question is does this change that?
So I'll defer to staff.
I mean, if that's the way it is today, so be it.
I gotta imagine that they make all structures comply with setbacks, but I'll defer to Brad on that question.
That's correct, David. It's not going to change that. And to Denise's question, it's rarely an issue because generally the amenity center is constructed before the people are purchased the homes around it, so they know what's there when they go to buy it. So you know you're right next to a playground if that's the case. But
My concern is for someone buying in a new neighborhood, it would be that if it were backed up to an existing neighborhood.
okay.
And again,
The-
if
the
it's
neighborhood
not
itself
changing
has
the
buffer
status
standards?
quo, I don't have an objection. All I'm asking is this changing the status quo?
I think all it's changing, based on my understanding, is that a neighborhood park that's required by code doesn't need a special exception approval.
Fair enough.
That's my understanding of the change. It's not affecting anybody's setbacks. Is that accurate?
Accurate.
Okay.
Denise, while we're on parks, is there a limitation on the size of the park that can be built?
Limitation on the size of the park?
Right.
I believe there might be someone online for a neighborhood park, that is
Yeah.
what you're saying?
I don't know the definition of neighborhood park. I know there's regional parks and so on.
There's only
So,
minimums
so I
in
can
the
probably
code.
answer that question.
Yeah.
There's minimum sizes, but I'm not aware of any maximum sizes, and usually the market would stop the developer from making their entire neighborhood a park. I mean, 'cause they're gonna wanna put lots there, they're gonna sell homes.
Yeah.
They're not, we never needed to put in a maximum because the market stops them from being a maximum. Does that make sense?
It does. Where I'm coming from, I guess, is at one time in my life, I worked for a Parks and Rec department. And sometimes parks can have a negative impact. You know, I worked in a community that had certain elements that would use parks for activities which were not positive. Gang fights, that type of thing. I know it becomes a policing matter at that point in time. So that's why I was looking at the fact that the size of a park. I'm not concerned about too much of a neighborhood park built in.
Yeah,
So this is not like a regional park or like a private park or that type of thing? This is like the neighborhood parks that are required, like an open space neighborhood park requirement in the land development code for a subdivision.
Yeah, that's why I was asking about the size, David. I was looking at, for instance, you have Wesley Chapel Park, a beautiful park out there. And when I first moved to Pasco County, I worked with some folks to try and create that park out there. And at my age now, I don't really have that much of an interest in parks other than the fact that it does benefit a community as a whole. But I'm concerned about as communities grow, like the west side of Pasco County is relatively older and mature, and I know that there are probably some gang activities out here, and and that's all I'll say about that. So they tend to gravitate to parks for a variety of reasons.
Okay, so let me be clear. The parks that this is talking about are only neighborhood parks, not the county's district, regional, large parks. Okay, so they're neighborhood parks that are typically maintained by an HOA or a CDD. And those HOAs and CDDs can secure those parks however they want to. So if they want to, I live in a CDD where our basketball courts have fences all around them, and you need a secure entry to get into the basketball courts. So there are many HOAs and CDDs that secure their facilities to address the very issue that you're talking about.
Okay.
And there's nothing in our code that prevents that.
Okay.
What our code requires is they have a place for the residents to recreate. It doesn't say they can't secure it in some way.
So basically.
As long as it's available to all the residents that were assumed to have been using it in
No,
the
that's
code.
CDD
So that HOA or that CDD or whatever neighborhood was assumed to be using that neighborhood park, as long as they all have accessibility to it, then they can secure it however they want to secure it.
okay.
So, but these are not your typical county, district, regional parks that tend to be open and unsecured. They're only the neighborhood parks which they can secure them if they want to, or not secure them. If they don't think it's a problem, they don't have to secure them.
Okay, thank you.
Okay.
Okay, the next section is 500 zoning, 517.3. This is R4 high density district. It basically modifies the lot coverage to be a combination of principal and accessory structure coverage to 65%. So you
Thank
just heard a
you.
variance right before this one, and, they just couldn't wait till the code get updated.
Had conversations about this.
Yes, you have, so you're welcome.
Thank you.
The next section is, this is a Scrivener's error, 522.3, Q MPUD conditional uses. Changes the section from 401 to 402, should have always been 402. And it corrects the term short-term rental. They've been called vacation rentals for years and years already. And modifies 401.5B to 402.5B. Next section
What's the
is.
what is the restriction now on vacation rentals?
So if the vacation rental did not exist prior to the adoption of the ordinance in 1999 and was actually, what is it called? Those folks were required to register. If it's not in the plat that you can have vacation rentals or in the MPUD plan, then it requires a conditional use. You've heard one, and actually, you just heard another one not 2 planning commissions ago for Mr. Malikos. So they have to go through the conditional use process.
Is there any active enforcement of this going on? I mean, now that we have VRBO and Airbnb and the like, and I mean, I can tell you, I know someone who cleans these residences, these vacation rentals on a weekly basis every
I
Saturday morning.
can follow up with code
and-
enforcement as to what their enforcement activity is on these. So I'm not familiar with, David, have you heard anything in the county attorney's office, whether that's something that's being enforced?
Because I'm sure there's a lot more of them than there are registrations.
There may be some.
Oh, I have
enforcement-
very little registrations.
Yeah.
I think I'm down to 10.
So,
Well, there's
Well-
more than 10.
you have to remember that the tax collector is enforcing the collection of the tourist tax, which is probably the primary enforcement mechanism to make sure that if they're operating as effectively a hotel, that they're paying the tourism tax to the tax collector. So I think he does some enforcement, but I'm not privy to everything that he's doing.
Just curiosity.
But part of the reason we turned it over to the tax collector to do those collections is because we wanted him to help with that enforcement.
Okay.
But I think Denise is correct, from a zoning perspective, I'm not sure we're doing a lot of enforcement,
Right.
unless unless we get a complaint of some kind.
Well, for the most part, I mean, these types of properties are well kept. They have to be.
Oh, absolutely. Like I said, I know somebody who they make their living cleaning these things, and every Saturday morning, they gotta go clean them up before they get turned over, and,
Yeah.
yeah, they are
Usually they're
absolutely
not
kept. That's how
They're
the
not
people make their
they're not
business.
blighted like a lot of the rental properties.
But occasionally, they go there, and on Saturday morning, and then the place is trashed, because they got a rowdy group that took it, and
So next section is 522.52A9. It basically adds animal hospitals and veterinary clinics as permitted uses. Previously,
You
it
need
was
to
special exception use.
Advance your slide.
Sorry about that.
Oh.
Is this where I should be? Okay.
Yep.
I wonder where that was.
Following section is 800, natural and cultural resources protection, tree preservation and replacement. So this is the agricultural loophole. It hopefully closes that loophole. We do, I don't know if David wants to talk about.
Well, this is
talk
another
about
one
it.
that arose out of a planning commission meeting,
Yeah.
actually.
This was CPAP, right?
Yes, it was, so if you recall, there was an allegation that trees were being removed under an agricultural exemption. And if you recall, I stated that the code says that that exemption expires once you submit an application for a site plan approval. I asked Brad at the time then what happens, and I'm not sure that certain people were happy with his answer under the existing code. So we've tried to clarify exactly what happens when that agricultural exemption expires. So in 2016, we changed the code to say that it expires when the site plan is submitted. But it wasn't clear about what happens, how do you measure the trees that were removed once it expires? So we've added language that clarifies that we'll look at aerials and other surrounding areas to determine the trees that were removed. The other thing that it doesn't do, the existing code, is it didn't really create a safe harbor for what I would call true ag properties. Because the intent in 2016 wasn't necessarily to stop a true agricultural operation from removing trees. The intent was to try to stop people from using that exemption solely to avoid our tree mitigation requirements. So we've now created a safe harbor that says that if you've been under ag zoning and agricultural classification for at least 5 years, or you've been under ag zoning and agricultural classification for at least 2 years, and then you wait at least 3 years to submit a site plan application, that those are permanently exempt. In other words, they're not, because we're considering those to be true ag operations, they weren't doing it solely to avoid our code requirements. So that's effectively what the code amendment does. It also clarifies when tree removal is allowed in a wetland, and it's basically only if it's been gotten either a permit exemption from SwiftMud or they're following best management practices that are adopted by the Department of Agriculture. So that's effectively what is done. It's basically trying to clean up something that we did in 2016, but we didn't finish the thought process on it.
I understand where you're going, and I wasn't a member of this commission when that particular case came, but I was watching it that day. So the question I have was the accused actually, or does the accused actually practice agriculture on his property? Is he a rancher? Is he?
So the statute,
Practice
yeah, so the
silviculture.
statute requires that it be a bona fide agricultural operation. I don't have enough facts to know whether he was actually engaged in a bona fide agricultural operation. If he wasn't, he would not qualify for the exemption at all.
Okay, and then,
But if he was, this makes it clear that that exemption expires as soon as he submits a site plan approval,
sure,
unless he'd been doing it for 5 years or 2 + 3.
and I will tell you that I have a sort of client that I know has done the same thing. But I have some concern that we're establishing a time frame, 5 years, that may not be reasonable for someone. Someone may actually, we may catch people, there may be an unintended consequence here. one of the thoughts that I had as I was reading this is somebody moves into Pasco County and sets up a blueberry farm. We had a lot of those going on for a while. They set up the blueberry farm. They do this for a year, and then all of a sudden war breaks out in Russia and the Ukraine, and the cost of fertilizer goes through the roof, and then Hurricane Ian comes along and destroys the fertilizer industry in Central Florida, and it becomes no longer economically feasible for him to continue his blueberry operation. Now he has to wait 3.5 or 4 years before he can opt to develop his land when he was legitimately practicing
So to be
agriculture.
clear, it doesn't say that he has to wait 3 years to develop his land. It says that if he submits before then, he's gonna have to mitigate for the trees that were removed.
Well, right, but in this case, here you're catching the guy. The intent was to continue the agricultural operation, but because of market forces or things that are beyond that person's control, they're now caught up in this.
Yeah, I mean.
I understand
Yeah, I
you
mean,
have to draw
the
the
problem,
line
the problem is you
somewhere.
have to draw the line somewhere, because the problem we were having is that people were claiming the ag exemption for a very short period of time, for the sole purpose of avoiding tree mitigation requirements. So I don't know where to draw that line. I mean, Clark Hobby raised a similar concern. That's why we changed the 5 years to somebody who can only does it for 2, but then they wait, because the waiting stops the potential abuse. Because otherwise what happens
Well, I don't
is somebody comes in
disagree.
and says, I did a blueberry farm, and then they submit their site plan application the next day. I mean, that's the problem we're having. And so that was the problem we were having in 2016 when we originally said that the exemption expired.
So, if someone wants to exercise the exemption for tree removal, are they required to pull a tree removal permit? I would tell you that in the case of my sort of client, because he's never paid me $1, all he did was email Will Poon and say, I intend to have an
So-
agricultural exemption in place on my property before March 1st of whatever year it was, and bing, bing, he went out and cleared all
So
the
I
trees.
believe the code exempts them from tree removal permits, but Brad, is that clear?
Yes, that's correct.
So the question is, could we require them? I'm looking at this whole business of, okay, so once the exemption expires, then we've got to try to determine if they owe mitigation for trees and how we're going to determine it. Would we be better off to require them to request a tree removal permit pursuant to the exemption, and then provide a tree survey at that time, so there's no question? And my partner and I went back this morning, we just looked at a few properties and said, can we actually count trees off an aerial photo after the fact? And it was pretty easy with some cypress trees and some pine trees, but man, when you got oaks and they were joined up in a cluster, there was no way to tell how many trees. And then the mitigation's based on the number of inches at diameter of breast height. So how can you look at an aerial photo and say, well, that tree's 10 inches, that one's 12, that one's 14? That's almost an impossible task.
So our experts or arborists do believe that it's possible to do with aerial photographs, and not just aerial photographs, but also comparing similar trees in the vicinity. So they can look at an aerial, and they're also saying that our aerials have gotten way more sophisticated, because you have street view now. So you can look
Oh,
at,
yes.
you can look at street view, and you actually can measure,
Only on the street, though. I can't go
I understand.
Can't go
but-
back into his 100 acres.
Okay, but I'm saying they can determine with pretty good certainty the size of the trees that were removed based on aerials and or comparison of trees in the vicinity. To your first point, though, we were trying to strike a balance. So you can do a survey before you start removing trees under ag exemption. That possibility's in there.
Right, and I read it and I go, why would anybody in their right mind do that?
Okay, but that's
I'd make
the
you do it for the
answer to your
aerials.
that's the answer to your question, though, is we didn't want to make every ag operation have to do tree removal permits. I mean, that wasn't the intent in 2016, nor is it the intent now. That's just more burden on Brad's staff. If it's a legitimate ag operation, to say you got to do a tree removal permit every time you clearing it for ag. So If they want to do a survey, that option's available for them. But if they don't, while we're saying, and you don't qualify for the safe harbor, then this specifies how we'd measure what was removed. And it doesn't go back for eternity, it only goes back to 2016. This isn't, because that was when we
Yeah, I
first
saw that.
did that. We're not saying we're gonna go back till 1912 and figure out what trees were there. Because there's, most of the agricultural clearing that occurred well before 2016. That's from what I've seen. So we don't think anybody was intentionally doing it to avoid tree mitigation, but certainly if they did it before 2016, before they knew that it was gonna get expired, we can't really blame them for that. But in 2016, we clearly said it's gonna expire at some point. So the problem is that we just said it expired, but then we didn't say what happened in 2016. So that's what this is trying to clarify. I acknowledge there are some jurisdictions that require tree removal permits, even for ag. And we could certainly go down that path, and that would give you a certainty as to what was there. But it's an additional burden on the ag community, which we didn't want to impose. That was not our intent. Our intent was to stop the potential abuse of the ag exemption, not interfere with legitimate ag
Okay,
operations.
so then the question then becomes, and I can be convinced, why 5 years, why not 10 years, why not 3 years? That's a number picked out of the air.
I think 5 years came from Hillsborough. They have a similar provision that talks about when is something considered ag or not. We got a comment from Clark Hobby that seemed a bit long. So, based on that comment, that's what we created the additional one for 2 years, as long as you wait.
Right, but as long as you wait, you're still making it 5 years.
True, but again, it's not saying that you couldn't develop, it's just saying you wouldn't be able to rely on the permanent ag exemption.
I understand that.
And so, it's kind of a policy issue. I mean, if the Board of County Commissioners told us 5 years is too long, or if the Planning Commission wants to recommend a shorter time frame, that's not a legal call. I'm just saying that what staff came up with was 5 years. So, the issue we were trying to deal with was, when is somebody a legitimate ag user? Obviously, 2 months is probably not legitimate. I mean, so, but where you draw the line,
I agree with you. It's a policy issue that ultimately somebody will have to decide whether maybe they'll try 5 years and determine later
by the
it
way,
should have been 7, or
by the way,
it
the
should have
one
been 2.
particular one that caused this whole uproar, my understanding, assuming he was bona fide, and I don't know if he was or wasn't, but assuming he was, he had been doing it for over 5 years. So he actually would have qualified for the safe harbor. So even though, and that's hard to explain to the commissioner that called me and said, what the hell are you doing? But at the same time, you have to protect legitimate ag operations.
Sure.
And so the fact that we didn't catch that particular guy, I'm sorry, but you gotta draw the line somewhere as to what is a legitimate ag operation. I don't know if it's 5 years. Okay, that's what staff is recommending. If the board tells us it's 2, 3, or 4, I don't care.
I understand your line of thinking. That's what I was trying to understand, is what's
The real issue we had
rationale,
was
so you
that
just have to
was
pick a number and-
people were basically saying, we're ag exempt, and then literally within 6 months, a year, they're saying, they're submitting their application for a subdivision.
Right.
And so, in that case, it appears that they were doing it for the sole purpose of avoiding tree mitigation. That's what we were trying to stop. I do agree, though, that there's some line, though, where somebody's doing they were not clearing trees just to prepare for development. They were doing it because they were doing legitimate ag operation. But you have to draw a line somewhere, as you said, and we did the best we could.
Fair enough.
And by the way, in 2016, we didn't even have a safe harbor. It just said it expired. So there wasn't even a safe harbor for the people that have been doing it 30 years. So one could argue that it's an improvement for the legitimate ag operation.
All right, coming down to the stretch.
Oh,
Next
no, we're
section,
just getting started.
being modified. I love you, John. Next section that's being
Just not today.
modified is 805. 805 wetlands. It adds FDEP as a reviewing and or permitting issuance agency. It further clarifies that public roadways are not subject to reasonable use test determination. It provides that the reasonable use determination applies to non-public roadways and linear public and private utilities. And it removes that statement about non-gated roadway open to the public travel in the public roadways section.
And it leaves the decision solely to the county administrator
That's-
or his or her
For the reasonable
designee.
use yes,
Okay, so
the reasonable use
question is,
determination.
if the applicant feels like the county administrator unfairly denied them in that reasonable use determination, does the applicant have any opportunity to appeal it to this board or to the
Yes.
county commission?
They
Okay,
can appeal
fair
it to the
enough.
planning
It's
commission.
in 407.1.
Yes.
It's in the appeal section.
And by the way, it would be appealed to this planning commission
The planning
first,
commission.
and then only if they didn't like the planning commission decision, would it go to the board of county commissioners.
I've always had a problem with the wording and/or.
Because SwiftMud could be the permitting agency. So like Southwest Florida Water Management District may be the permitting agency, Army Corps of Engineers may be the permitting agency, it's not only FDEP.
It depends on, if we were doing a subdivision, SwiftMud would have the jurisdiction, but if it was just something that happened on a single-family lot, FDEP would have the jurisdiction. Or if it was a project in which FDEP would otherwise have permitting jurisdiction, say for a new county wastewater treatment plant, FDEP would be the agency that permits wetland impacts.
So why can't we just state what agency has a responsibility for what? Because sometimes agencies
But
will
it does
say,
say
well,
as
it's-
applicable.
No, it's his responsibility, and the other one says, no, it's your responsibility. No, or, you see what I'm saying? That's, it kind of,
The Florida Fire Prevention Code and the Florida Building Code like to use the term AHJ, authority having jurisdiction.
okay. Well, I still have.
We do have the folks from Natural Resources, I'm not sure if they want to add, they are elevated to speak if they would like to.
It's-
the matter.
It's just, I'm not going to win the argument anyway, so, you know, I just always have had a problem with that, because when I worked for this agency
contagious
before I
now.
retired,
I did it.
it was always, well, it's and, or it's or, you know, and nobody got anything done. So, or it was my way of getting out of something too. Hey, it's or, it's there, you know?
So,
Anyway, it's
to
just.
my knowledge, we've never had an issue with and/or being misinterpreted. So, but.
And it also, there's a comma as
even-
applicable
even
every
Mr.
time that's
Moody has
mentioned.
never had that fight with us.
Yeah, federal system is different.
All right, next section
I think we're
is,
just getting clarification.
next section is 901.5, that section is stricken because traffic impact study was eliminated in 2011 and it's now reserved. The next section is 905.2D, landscaping and buffering. This is per the direction of the Board of County Commissioners on 2/8 of '22. We're updating the minimum number of shade trees table for a lot that's less than 6,000 square feet. Now you need 2 trees before you needed 1. You've probably seen that in all the MPUDs that are moving forward through the Planning Commission already, because that's a direction that the board gave us. And then it also adds that a shade tree may be placed in the right-of-way that fronts the lot. So you're probably seeing a lot of street trees or that type of terminology, but we're now codifying that.
Denise, we're gonna have a discussion.
Okay, and it also
Can-
let me finish the
Guys,
section.
put this in.
It also clarifies that the buffer landscaping is to be located between the fence and wall and the street road right-of-way, not behind the fence wall on the piece of property. So, yeah, John?
Do you have a graph here? You have a
Yeah.
PowerPoint you were gonna show
How long
us?
is this discussion gonna be? We're taking a break.
Yeah.
We'll take a 5-minute break.
5-minute break, okay.
That's why I took my own break.
Yeah, I saw you leave. That's what made me think maybe somebody else.
I knew John was just
Denise,
getting
are you going to
started,
get
so.
to sidewalks? Because I think the one I took sort of is 90,
Sidewalks?
yeah, that's the one.
I don't know that we have a section about sidewalks.
Yeah.
Fences, and then non-conforming signs, and then concurrency.
Okay.
Yeah, we don't have anything else. We don't have anything about sidewalks.
Well, Dave, if I can bend your ear for just 30 seconds, I think sidewalks should be.
my opinion,
No, yeah, because Chuck wasn't
it'd be
here.
better just to have the HOA do
That's
it
right, I stayed
and
and
then
listened
assess
to
the
every one
residents
of
for the
them.
cost. I understand your point, but I think it's the only way you know it's gonna get done.
Yeah, well, I'd prefer the CD to do it because that's a tax to me, which I can take off my
Or CDD, I meant, there'd be some
Yeah,
common
I know,
entity to do
but,
it.
yeah, but,
I don't like it when individual homeowners do it, because I don't know that they
you know, but the
do it
county,
right or they do it correctly.
but the county has code enforcement that can go and enforce it too.
Well, hold your thought, because I got a couple pictures we're about to see, and it goes directly to your discussion.
Well,
I guess this is gonna be a longer discussion than I envisioned. I never took my break, so give me a second.
Yeah, go ahead. Take as long as you want.
Uh-huh.
We can get back.
I'll tell you what, you remember a couple months back, we talked about distance on having meetings in east side, west side? Well, of course, there's no neutral side, which is the center of the county. Today, it took me close to an hour and 10 minutes to get here, and I was traveling.
You know what I never understood, Peter? I never
Takes me to
understood
get
why
to Dade City. It takes
we
me an
do
hour
the
and a half.
east. I mean, historically, this county seat is Dade City. But because of the rapid growth that happened here in the 70s and 80s, this kind of became the
60s.
de facto. But I always wondered, why didn't we set up at that point, we should have said, okay, Land O'Lakes is the place for,
That would have been nice.
it would have been central for everybody.
Vote for that, huh?
Yeah, that would have been very nice. I appreciate that.
I know some political people in Land O'Lakes, and I had a long discussion. In fact, we had a meeting here one time, many years ago now. Exactly where does Land O'Lakes begin and end? It starts at,
This is
if you
true.
take 54 across,
4 to 52, and
no, well, okay, that's the north part, okay, but it starts really at the Suncoast or Veterans Highway, and it goes all the way over to probably I-75. That's how they consider it, because we were having a dispute at the time on that,
All the way to I-75?
oh, yeah.
where is Wesley
San
Chapel
Antonio.
begin and end?
San Antonio on the other
Wesley
side of-
Chapel really technically starts about,
Yeah,
it
but
goes
if you
to the
take
east as far
52
as,
Out to 75, it takes in a lot more than just Wesley
Long
Chapel.
way.
San Antonio and,
well,
yeah.
Well, San Antonio would be on the other side of, after you pass under 75 there.
well, that's how they felt about it, and, or she did. And she was a good person, and we used to go around and around about that all the time.
I know who you're talking about. Probably Sandy Graves, right? Yep.
Yeah, she and I went around that, the outlet center there. I wanted that in Wesley Chapel, because technically you got that creek that goes through, which is named Cypress Creek, that's it. I said, well, why don't you take everything west of Cypress Creek, and we'll take everything south or southeast of that, basically, and that would have put that Tampa outlet into, well, and I don't like the name Tampa, but into Wesley Chapel area. Oh, man, I thought she was gonna shoot me, man. Check my tires
She's
on my
very protective of Land O'Lakes.
Oh, she is. She is. But she's a good person.
Yes.
And where does loot start?
Well, that's always a thing
That's another
too.
question.
By the railroad station down there in Hillsborough County. That's where Lutz is at. But no, actually, one of the individuals who used to be in the chamber for Wesley Chapel owned a business that was on Wesley Chapel Boulevard. Her mailing address was Lutz. And she was like about a half a mile, not even that far, about a quarter mile west of where we live at for Lexington Oaks. When you drive in Lexington Oaks, her business was probably about 1,000 yards down, if that much, and it was Lutz. That was her mailing address.
Because everything south of 54 along 41 is Lutz, right?
Yeah.
Technical, I mean, as far as mailing.
Yeah, I mean, that,
Yeah.
Same with Spring Hill, right? To me,
Spring
Spring
Hill,
Hill
yeah.
was always in Hernando County. Now, if
Right.
you're on Shady Hills Road, your address is Spring Hill.
Actually,
Yeah, I know. That's
Just north
crazy, isn't
of, just north of 52 on 41. That's where it starts.
And that's where Pat Millard used to live out there.
yeah.
that area.
Right wherever you guys are, sorry about that.
Sorry, anytime. All right, now that Liam's sitting, we can go start.
I will try to be brief. Can you
That's
show
it.
the two PNG files? Actually, there's 4. Yeah. One's close, one's zoomed out, one's close in.
You want the close-up?
Sure, the close-ups will tell you the story better. So this is my concern with planting trees in the right-of-way. There was
broken
just a
concrete?
recent amendment to the land development code in the landscape and buffering section. And in a vehicular use area, a landscape island went from an 8-foot minimum clear planting space to a 10-foot clear planting space. But now we're going to say you can go out and you can plant trees in the right-of-way. So can we look at the set of the PDF file that's the plans for Starkey Ranch?
The utility manual one,
No.
the last one, the RWCM.
Yes, I think that's, sorry, did I not rename it? Okay, if you scroll down a couple of pages, you'll see the typical street sections for the streets in Starkey Ranch. And they're 50-foot right-of-ways like we typically allow. I think it's the next page. There we go. And in those 50-foot right-of-ways, the distance between the edge of the pavement or the back of the curb and the sidewalk, 7.5 feet. So now we're proposing to allow trees to be planted in an area less than we would in an island in a parking lot. I won't make you pull up all the graphics, but I also brought excerpts from the county's utility manual that doesn't allow you to plant trees over utilities, and it requires a clear zone of 15 feet adjacent to the lot lines in these PUDs so that tree roots don't grow into utilities. And it seems like that this proposal to plant them in the right-of-way directly conflicts with all of these things. And in fact, I won't do this because I know Chuck's in a rush over here. If we scroll down and look at the utility plans for Starkey Ranch, what we'll see is that all of the storm sewer, the water lines and reclaimed water lines are all in this strip between where we're proposing to plant trees. So are we creating a conflict? I pulled another section of the land development code over here. David, roadside design, and this is Section 9016E. Vegetation. Grass or other low-growing vegetation that is easily maintained shall be used on medians and roadside clear zones. And then it talks about that we shouldn't put landscaping in the clear zone. So I went, and there's a table in here with the clear zones, anywhere between 6 and 10 feet. Well, we're talking about 7.5 that's available in a 50-foot right-of-way. So I'm not sure that telling the folks we can plant them in the right-of-way is the best policy. I'm pro-tree. I like trees just as much as the next person does, but we need to be careful about putting the right tree in the right place. And then, since I don't want to just create a problem, I want to provide a solution. It says that you'll put a shade tree. Could we have an understory tree with shallower roots and smaller crown out in those locations, rather than something that's going to create problems for sidewalks, utilities? I understand there's a commissioner that wants all the trees. I get it, and I understand you're following her direction, but we need to think beyond. It's all fine when the tree has a 3-inch diameter at planting and a 5-foot crown spread, but over the years, when it becomes a 30-inch diameter oak tree and the roots are popping the sidewalk up, and we need to think about that when we approve the 40-foot wide lots. You have a 50 or 60-foot wide high tree and it falls, where does it go? You know, on a 20-foot setback lot, goes right into somebody's car, their roof. I just had one come down just before Memorial Day that was an 80-foot tall tree. And I was lucky that it didn't take out either my house or my neighbor's house. But I did have to get a crane to get it out of the other oak tree it was caught in.
Would have to be a tree with a root ball, like a palm, some kind of palm.
Right, that's what I'm suggesting, is that we should probably rethink the idea of putting the traditional shade tree, oak tree, sycamore tree.
In the yard.
Maybe we could go with things like crepe myrtles that are smaller and.
Yeah.
I thought Brad, I thought the county did update their tree list, didn't they?
Yes, the tree list is updated. Any tree has to be the right tree for the right place. So if there's a certain amount of space for a tree, then the tree that goes there has to fit certain definitions. Root barriers are also required now that weren't then, that obvious from some of the
But
pictures
this
that you're showing.
ordinance says that it needs to be a shade tree, and at least one of them has to be planted in the front yard, and I assume we're allowing it in the right-of-way in lieu of planting it in the front yard.
That's the intent.
And the reason is because we only have 20-foot setbacks to these houses, and there isn't enough room to plant these trees.
So Brad, could you address whether it's possible to put a tree in the right of way?
At this level, I cannot, because we need to be looking at a specific plan and a specific location to be able to say whether something can or cannot go there. Different shade trees can go in smaller spaces. You'll see in New York, there's tree wells all over the place and not a drop of anything else. And it doesn't destroy sidewalks or anything else. There's ways to plant them. So if an engineering firm or a developer is willing to do certain things to ensure certain things, they can go with certain types of trees that maybe we wouldn't if somebody wasn't willing to make those accommodations. So we have to look at it on an individual case-by-case basis. So at this level, this is kind of just giving the basic framework, but when it gets down to actually looking at the landscape plan, we'll
Okay,
make
so-
specific comments.
Well, the question becomes, the amendment is that we're allowing it in the right-of-way. It's already covered in 9016E. It says you can plant them in the right-of-way. Well, it doesn't say trees, it says grass or other low-growing vegetation that is easily maintained. And so long as that it's not placed in the roadside clear zone, and of course, if these are public county rights-of-ways, they're required to meet the minimum uniform standards. You have to sign the MUM statement, because it's connected to the county roadway network. So you have to honor the clear zones.
Well, this is what, Brad, I wasn't asking you, this is what I was asking Brad the question. Have any developers put it in the right of way and met all the requirements that John is talking about? Has it, that's really the question. Not, I'm not asking you to say whether a particular development can or can't do it. I'm saying, is it possible to meet all the requirements John's talking about and get it in the right of way?
Yep.
Can you
So
show
I
me an
think-
example?
I really cannot without, I mean, we're completely speculating. There's too many variables for me to be able to say. But yes, you can design it so that, within that area of right-of-way, if utilities, for example, are backloaded into a house instead of front-loaded into a house, then that area in the front, yes, you could absolutely do something. We work with utilities on that. We work with a bunch of different people on that and coordinating that to make sure it's the right thing in the right place. As far as clear zones, clear zones have other things associated with them, speeds and other types of issues. So we certainly look at all of those things when we're looking at those plans. And if we feel that something is not right for the location, we don't allow it.
I think the intent of this code section amendment is to ensure that there's at least one tree in the front.
Yes.
I think what the development committee was asking us for clarification on is that if they're able to meet all these requirements that we just talked about and miraculously able to get it in the right of way, that they shouldn't have to put another one in the front. I think that's what.
And I'm 100% on board with that. And my message in all of this would be, if we want to have street trees, and I know we have a commissioner that wants a street tree, that's good, but we can't, you're going to find it very, very difficult to do when we're doing 40-foot wide lots and 50-foot wide rights-of-ways. And like I said, we've got 50-foot rights-of-ways shown, geez, I think it might even be the same ranch in that particular neighborhood, and there's only 7.5 feet between the back of the curb and the sidewalk. We require 10 in a landscape island.
Actually, I think the way our code is written, if it's less than 10, you have to provide certain accommodations like root barriers and different things like that. There's some language in there, I believe, to address your concern.
All right, that's all.
But I don't think there was any intent to say that everything you said doesn't apply. I think this is just saying, if you can comply with all those things, you don't have to duplicate a second tree in the front yard. I think that was the intent, right? Denise, Brad, somebody?
That's the intent.
Okay.
Can you move me over, because for some reason, I can't, okay, there we go, perfect. All right, next item is gates, fences, and walls. This is per the direction of the Board of County Commissioners on March 8th of 2022. So the section now, in the general portion of that section, states that chain link, aluminum, or similar fences and walls are prohibited that are visible from collector or arterial roadways on the highway vision plan and functional class map. I do want to clarify that there are some exemptions in that section, particularly 1003.2, that exempts gates, fences, and walls on property that's being utilized primarily for agricultural purposes. So that's, because I know some of our folks had some concerns with that
Mr. Gray,
section.
I promise I have no more comments after this section.
After this section, okay.
I find that hard to believe.
This isn't the last one?
So this is the last one, okay. Wow.
My notes end here. We're clearly trying to ban or prohibit a style of fence. I'm not sure that the language, David, bans a style. You're banning an element on the periodic table of the elements, aluminum. So if I come and I make the fence out of steel, copper, platinum, magnesium, that's okay?
No, I think it says or similar fences.
Okay, but so what
Chain
does,
link,
what does that,
aluminum,
what
or
is it
similar.
that we're trying to ban? I don't think we're trying to ban a material, we're trying to ban something that we don't like the look of.
So let me
So
ask the
what is
question
it
a
that-
different way.
what is it?
What is an aluminum fence? Because I think we all know what a chain link fence is.
Right.
What does staff mean by aluminum?
So it's made out of that material that's aluminum. So some folks, they're kind of like,
Like
they almost
blinds,
look like, say it again, I'm sorry.
like blinds that you stick through a fence.
Yeah, they kind of look like that, and then there's also some of them that will do like aluminum wire fences.
Canvas, they do.
Well, I guess, but I think I understand Mr. Moody's point. All right. He's starting to convince me he's right. So,
Oh, boy.
that's a scary, somebody get that on record.
Delete that, will you?
Well, I think,
And I do want to say that I did hear the board, I listened to the board a couple of times, and they did specifically say they did not want chain link fences, so that was
the chain link
specifically
is not the
stated.
issue.
Yeah.
I think, because that's a type of fence.
Yeah.
I think Mr. Moody's point is that aluminum is just a material. It's not a style, and so, for example, you see our typical PVC fences, that could be made out of aluminum.
Yeah.
Okay? I realize it would be expensive and nobody would do it, but are we saying that's prohibited because it's made out of aluminum instead of PVC? I mean, I think staff probably meant that this was a fence type as opposed to a material. So I guess the question is there a better term to use than aluminum, something similar like we did with chain link?
Before I came in here, I looked up, and there, are all kinds of very ornate aluminum fences available on the market that I don't think we're trying to prohibit here. I get it, we don't want to have a wire fence, and in fact, I got somebody in my neighborhood put up a picket fence, and it's
So-
made of metal, and I think it looks
My,
like,
my recollection from the board discussion was it was chain link and barbed wire that they were trying to prohibit. I don't remember, maybe
I think barbed wire was a separate discussion on another day, because
Okay,
it
well,
wasn't on
but I don't
3.
remember a board direction to say that we shouldn't allow just because it happens to be made out of aluminum.
Right.
I think that's Mr. Moody's point. That's not a fence type, that's just a material. So I don't know what the board intent was, but I am agreeing that there probably wasn't a board intent to just eliminate a fence just because it would happen to have aluminum in it.
Specific type of material.
and
Yeah, like stockade would be a style, you know?
right, that's what I'm getting at, is I think you want
Now,
to
some of
refer to a
those that are all,
particular
those
style.
wooden stockade-looking fences, you know?
Yeah, I think whatever
after
the
they're up
fence
for a
type is
week,
that
they
we were
look
trying
bad.
to prohibit here, it probably should be listed
Call it out.
rather than
Okay.
aluminum.
The same thing,
Will
it
do.
says, and gates, and I'm trying to figure out in my mind, how the gate, regardless
There's
of
a
its
chain link.
material, is not going to be visible from a right-of-way. I got a road, and then I got a driveway perpendicular to that road, and a gate, whether it be 10 feet or 75 feet set back from the right-of-way line, it's visible. And lots of gates are aluminum, and they could be very ornate gates.
Well, okay, but it always goes back to, that's modifying, or similar fences and gates that are, it's modifying the original terms, which is chain link and aluminum.
Right.
I think the bigger problem is that we didn't identify a fence type. We identified a material.
Yeah.
So I think if you clarify the fence type, and then it said or similar fences and gates, it might work, because it would have to be something similar to that fence type.
And then the last question on this topic. It says.
No, you already had the one.
No, I said after the section. It says that along a collector or arterial road, that these types of fences shall not be visible from the right-of-way.
Mhm.
Is that apply to existing fences?
That's not the intent.
Can that be clarified? Because when I read that, that seemed to me that an overzealous code enforcement department could go out and say, oh, Mr. Boat and RV Storage that's been operating here for 20 years at the corner of Grand and
So-
Green, I see, the code says you can't see your chain link fence from the right of way.
So what you don't have here is there's a general requirement when we adopt any change in the land development code that talks about its applicability.
Right.
And it basically exempts anything that's already gotten a county approval of some kind.
Right.
She's not showing you that here, but that.
Not
that
showing you that here, but
that
it's in the
applies-
applicability
That applies to
section in the
all of our land
ordinance
development
itself.
code changes. They apply basically prospectively. They don't apply to something that already
That's
exists.
Right.
reasonable.
So if somebody's fencing in retention ponds, which we see that a lot with chain link, what would they be doing that with now?
You mean for safety purposes?
Yeah.
Yeah, I mean, I see all kinds of 52, State Road 52, 56, I see retention ponds.
How would you know if there was someone face down floating in the retention pond if you couldn't see through the fence?
Well, chain link you could, but
Yeah, chain link, but I'm saying that if we're not allowing chain link, what?
Aren't there
would
other
be-
types of material, like the white vinyl picket or whatever, that can be seen through, as long as you have
Not as
the
effective as,
picket separated enough?
brings up,
I mean-
if you had, the body's kind of it's not that far-fetched. It could be a small child climbed up, did something, fall in the pond, but there could be somebody doing something illegal in there. You would want some visibility, and if you were a deputy or from law enforcement, you'd want something to see the area clearly. There is legitimate concerns about that one, especially with the water.
I just did a pre-app for a boat and RV storage place, and they explained this going forward, and then there was actually debate as to whether or not the boat and RV storage could use chain link fence for security purposes. So I think there needs to be clarification.
Well,
in
there's
this.
other sections in the code, so it talks about, so, I mean, I didn't print out the entire 1002, but I can show it to you. I'm thinking of another section. I didn't print the entire 1003 on there, but I could show you how there's other, this is just the general requirements, but then it talks about other requirements for commercial. So like, it talks about, like, the barbed wire has to be at 6 feet on the fence and things like that. But I think the intent of, what the board's intent was, and I remember watching this board meeting, is that they were showing photographs of what they considered very unattractive, things that they didn't consider would be of a premier county, seeing all these chain link fences and those type of fences throughout the county. And they tend to also rust, and, you see those type of things on chain link fences.
Yeah, so this is from an aesthetic standpoint.
That was my recollection of that
Yeah,
board
but
hearing, that it wasn't premier to see that from you're driving into the county and you're seeing that on these collector and arterial roads.
Yeah, but you also heard from at least two individuals here that there needs to be something that concerns the security issue and/or from a law enforcement visibility of certain pieces of property. Yeah, if you, in other words, security is a concern too that needs to be considered. I can see the aesthetics of it. Everyone, as you call it, a premier county, but you also want to have a safe county. So that's the other issue. Sometimes the two don't always come close together, but have to be weighed as considerations. And I think security is a more of a concern than the aesthetics, from my perspective. Maybe others would have a different viewpoint, but anyway.
So it says the only thing that you could think of, like a pond, that would be,
Yeah, I
Well,
mean,
I'm
it's
thinking
sort of,
about-
it's sort of like you have to fence in your swimming pool so people won't fall in it, and I could see where that would be an issue if you had a pond,
I guess the question is there a fence type that provides that security that would still be consistent with the board's direction?
What would
So I
be the
believe the-
expectation for, I'm going to use this example of boat and RV storage, it's a popular use. What would be the expectation of staff for that facility needs to be secure, so what, I'm sure the sheriff's department in the back of the room would probably have a problem if we just used white vinyl fence, and I bet the county commissioners would have a problem if I put white vinyl fence all along the side of Little Road, and then you couldn't see into the property, but yet it would meet the standard that's proposed here.
Well, there are some uses where staff and the board intentionally do want it screened, or they don't want it. Because, for
Yeah,
example,
but
if
you-
you have automobile storage in
You have to
a,
watch what you wish for, too, and if I have this 1,000 feet of monotonous white, cheap vinyl fence, and that stuff that doesn't last forever, and it looks great out of the box, but 5 years from now, it doesn't look so good. And it's, like I said, 1,000 feet of this monotonous fence. In fact, my own client asked if he could put banners on it and advertise other businesses. I thought he'd have a sign code problem, but we're looking at what are those alternatives then that he can do.
So I may be able to answer that. If you read the language of this, it speaks of fencing that is visible from the roadway. We require buffering in those areas anyway. You would not be allowed to put a white vinyl fence the length of a roadway. There would need to be landscape buffering in front of it. If you
Right, but the
wanted that,
landscaping isn't going to block the
if you,
fence
if you,
forever.
right, but it doesn't block the fence forever on a regular subdivision either. So, but if you wanted to use chain link to secure your boat and RV facility, you would be required to put some form of hedge line in front of it so that chain link is not visible from the roadway.
Okay, so you probably hit the nail on the head here, and that was gonna be the follow-up question, is when you provide that landscaping between the fence and the right-of-way, have you satisfied this requirement that the chain link fence is not visible from the roadway?
That's my understanding as to how we would interpret that.
Can we add that?
Now, that does not address your gate issue. I don't know how to necessarily address the gate issue because you can't plant landscaping in front of a gate,
Yeah.
but that's,
Kind of
you know,
just take the gates out of it.
then you're not secure.
No.
No, you can have
The need
gates,
that the gate
just the
can't be
material.
visible from the
Yeah.
roadway.
Yeah.
Or that you can't use a chain link gate, that you could make a decorative gate, swing gate, lift gate that's aluminum fabrication with pickets that are, 2 inches wide that I can only put a golf ball through that, the guy can't steal my boat motor through it. Although they're amazing on how they can figure out how to steal those boat motors.
Take it one part at a time.
Yeah.
well, I guess I'll ask Brad and Denise, based on this discussion, do you think there's changes that can be made to this language that
To make it,
would address the concern but still be consistent with the board's intent?
Well, I mean, And, you know, definitely defer to Brad from the landscaping perspective, but I mean, what level of opacity would that landscaping have to have in order for it to completely block the view of
That's why
the,
the question.
yeah. Because I mean,
for
when you
instance,
first
like-
plant the landscaping, typically it takes a while for it to grow.
Like you have in the type B buffer definition, a requirement that if you want to use a hedge, in a continuous hedge in lieu of an opaque fence, that there has to reach 80% opacity within 12 months or something like that. Can a similar language be added there so that there's safe harbor for someone who intends to use a chain link fence, but yet use landscaping to screen it from view from the public right away? What I don't want is, and it's all good, well, Brad's here running he's the development manager and you're the zoning director, but people come and people go, and the next group may not quite interpret it the same way as you. Other than David, he's a fixture.
Mr. Chairman.
Not after today, it won't be.
Just kidding. Mr. Chairman.
Yes.
This is Nectarios Pitos with the Planning and Development Department. You know, with regard to ponds, not every pond needs a fence, right?
Right.
But some do. But I guess the one question that might be asked is whether a fence type is appropriate to specific situations, right? So you have to secure a particularly, you know, sloped pond, for example.
Right.
Would a chain link fence be appropriate in that scenario? I think the board's intent was to have my words, sort of a good business presentation and good residential presentation from the arterial and collectors. And so, you know, you could solve a deal of the presentation through landscaping. But I'm not sure that the landscaping would be the 100% solution to continue to allow the chain link along the arterial and the collector. That doesn't mean that the property owners potentially couldn't use chain link on other edges of their property, going into and away from the
But
from the
okay,
site.
so I opted to use a white vinyl fence. I have a project in review right now at the corner of Little and Bolton. Think about, it's got, I think, 500 or 600 feet of frontage on Little Road. You think about what, if I put up a white vinyl fence at the back of the right-of-way on Little Road and put some landscaping, tell me if that looks any better than some chain link fence there. Be one thing if I built a nice brick wall.
I think the issue with chain link is that you can see into the property, and whatever is being stored behind that chain link fence often is preferred to be unseen.
Well, that's debatable, though. If I have something very important that I want to maintain, and it's a very expensive item, I certainly would hope law enforcement would check on it every now and then, and I could check on it too, so, I mean, that's debatable there.
And I understand, you know, we're talking about a junkyard, but I've got people's $100,000 motorhomes out there,
Yeah,
and they're $70,000 and $80,000 boats. I don't think that's junk, and I would want the deputies to be able to see that.
Yeah, I mean, there's definitely a security
Well-
aspect of it, so somehow you have to come up with a way to
If I
fence
can,
them that it also is secure. And
if I can offer one other thing too, there, not all of the Vision and Collector roads, but on some of them, certainly, you know, this type of outdoor storage activity is actually regulated away from the frontages too, right? So like RV boat storage, for example, could not happen up along State Road 54 or Little Road or US 19.
Only in some specified places. That's not universal across the county.
Correct.
There are places, the market area, the redevelopment area, it is allowed. Like I said, I have one in review right now.
we're not really talking about commercial property, we're talking about more about residential type property, right?
Well, we're really talking about all properties in this case. This is the general provisions of the section.
That's where the problem comes in, because there's a lot of commercial properties that need security. And the only
I
way you're gonna
agree.
get it is with a chain
I'm
link
thinking
fence.
about the boat dealer there that's just to the north of Hudson Avenue, as you go around the curve on Hudson Avenue. Clearly, he wants his boats to be visible because he's a dealer, but he also has to provide security, because I know that he's had a long history of problems with theft of boat motors and pieces and parts over there. What does that
Car
guy
dealers,
do?
the same thing, some car dealers.
Yeah.
Like that too. Yeah. And it's not neat, I don't know.
Well, so, I don't know that we're gonna solve this issue today. I mean, we could stay here till 8 o'clock and.
No,
fight
we don't
about
want
it.
to do that.
Okay, so maybe to solve the problem, when you make your motion to move this forward, you just make a general motion that some allowance be allowed for security-related fencing. And then let staff figure, and the board figure out what that means, but I don't know that we're gonna solve, I mean, if that's your main issue, is that this is not allowing for security-related fencing and where it's appropriate, because I agree with you, it doesn't allow that, then maybe you just give staff that general direction to add some allowance for that, and then let them figure that out, how to do that.
And do we exclude gates? Because again, I'm just thinking of unintended consequences, how
Right.
many,
Yeah,
I
you
mean, my
almost have
property
to
has a
split it.
gate. I mean, I don't think I'm on an arterial collector, but what if I was? How many people are who have a gate, and then let's say they have to replace their gate? Now, are they gonna have to replace it with some really expensive ornate thing rather than just a regular farm gate?
David, would there be,
Well, ag is exempt
Is your
anyway.
property ag? Because that would be exempt.
Well, and then I guess it's a matter of perspective, because we do have ag, but I also live there.
Right.
So then the
Well,
question is,
it also isn't gonna apply to an existing, but I guess your point is that if your gate
If you
got
have to
torn down
replace
and
it,
you had to
right.
put one in.
and now I've got to spend a bunch of money to get some ornate gate.
okay, so that brings
That
up a
wouldn't be a
good
problem for a
question.
man like
Let's, let's say, and thank God it didn't happen, but we all thought we were about to be blown away by a hurricane here. Let's say that the hurricane did come and destroyed the chain link fence that surrounds the boat and RV storage on Congress Street just south of Ridge, or the one that's on Grand Boulevard at Perrine and Grand. Had the hurricane wiped that fence out, would they then be subject to complying with what the proposal is here? Even though they have an old site plan and they just need to replace the fence in kind, but it sounds like they might not be able to.
So there may be a,
That's why David is suggesting that we put a provision in here that they need to come up with some kind of an allowance for security fence.
there may be a general statement that we could add here that except in situations determined by the county administrator or designee where it's necessary for security purposes, kind of add that type of language to this, and then we can look at that. But I believe that my take from the board discussion was that they were looking at the visual aspects of it. Even places that are securing their sites and they're along a collector or arterial, they want to not appear as if they're just that site. So we can handle that with buffering and landscaping and make it not visible, with the exception of a gate situation. So I think we probably need to
Would there be
make a decision on the
problem
gate.
if we, well, I don't want to get ahead of myself because there's 2 more sections Denise still has yet to go over, but the question,
But you already said you're not going to talk about them.
no, I'm not going to talk about them. I'm all good with those. The question is, would staff have a problem if we voted to approve and then you bring the fence and gate back as a separate ordinance? does it have to be in this ordinance?
well,
So that we
okay,
can get
so-
a second
so-
chance to
so-
see if we
so-
agree
so-
with
so
what you're.
Legally, no, it doesn't have to be. If it gets pulled out of this, though, it's gonna delay it for sure. I don't know if the board will be okay with that.
I think the board has asked for at least one board member has asked for a status on this on several occasions.
Could
So-
you, let me just ask this question. Could you put the security type fence and then put maybe, let's say, for example, a white rail fence in front of it so it looks like it's, so the chain link doesn't show up? That kind of, you almost have a dual fence, but it's mainly just for appearances.
So our buffering code, where you can use a wall or a fence or a hedge for a 6-foot opaque buffer. In this case, you could use any number of things to create that opaque buffer. Are you going to see bits and pieces of fence through there? Yes, but you're going to create a break, like Mr. Moody was saying. It's not 100 feet of, pure fence that you're looking at. There, you may see some bits and pieces of things, but it's going to be an improvement over what's currently in code now. And I think that's what the board was
So I
looking
think,
David, can you do in 3 minutes and craft some?
no,
language?
this I can't. But I think you could send it forward with a general direction to deal with the aluminum issue, deal with the security issue, and deal with the gate issue, and just let staff figure it out between now and the time this goes to the board. I mean, if those are your three concerns, so that's what I'm hearing you all say, is that it's not addressing the need for security, it's not addressing, the gate issue may be a problem, and that the aluminum issue is a problem, that's probably sufficient direction for staff that they can work on those issues between now and the time it goes to the board. Without saying it has to I mean, I'm not telling you can't ask that it be severed from the rest of the package, but staff may get some heartburn from the board if you do that.
Well, I don't want staff to be berated by the board for something the planning commission chose to do. I think that would be unfair, but what I'm
We'll blame
getting
it on you,
at
John.
is we'd like the chance to come back and see what the revised, updated proposal is.
Happy to do that.
Okay, can I throw one more curve at you? I talked about the
Okay,
security.
well, can I ask, let me just follow up on that thought, though.
Sure.
Before you throw another curve. So this requires 2 public hearings, right? So in theory, between the first and second public hearing, we could probably bring it back
Yes.
to the planning commission to
Yes.
show what you came up with.
Absolutely.
Okay,
Yes.
that would be fine. with
That
me.
doesn't derail the process. You're okay with that?
I'd be okay
So
with
you
that.
did come up with a solution.
See, that's why we like you.
It was just under 3 minutes.
That and the blood.
Blood, so you want,
Oh, you want blood as well?
so the
Okay.
staff solution to blood relatives and the gate issue in terms of aluminum gate and security, you want, whatever they come up with in a solution, you want that brought back to you. But that would be in the context of the normal public hearing process for this amendment, basically. Is that what you're saying? Okay.
Yes,
Don't make any motions yet, because this is a public hearing and we have not asked for public
I
comment.
understand.
The only other item that I would like to bring forward is to have some input from the sheriff's department in, because I'm thinking of the road deputy that has to drive,
We're looking at them.
and, yeah, okay, and they have to drive by the locations that we spoke about, basically, boat storage areas, RV storage areas. They have to drive through, not through them, but they drive by, and they have to be able to at least look through the chain link fence. That's why I pushed for it. I see it as a problem that if you have landscaping in front of it, you can't block their view because they have to be able to see in it, or else they have to get out of the vehicle, shine their flashlights or different things. That's what they normally do, and it's a routine thing for them to do those activities. And trying to say, we need to have some input from the sheriff's department on how far that they want to go with this particular amendment. So,
I would like to hear from their comment to that too, yes.
yeah, because they're the ones that are going to be doing the hard work, as you say. And if somebody steals some motor from a boat, I won't say anything. I said enough.
so for this section, deal with aluminum, deal with security, deal with a gate issue, and then also get comments from the sheriff's office.
Well, I think the security and comments from the sheriff's
Yeah.
office are directly related to each other.
Yeah.
Yeah.
That's
Yes.
same general concept.
Yeah, but typically I don't ask for comments from the sheriff's office, so.
Well, I noticed in one of the cases, there was comment from the sheriff's office. It had nothing to do, the comment had nothing to do with the particular project. I think it was a comp plan amendment. But I saw the comment, and I don't know if Mr. Naco's listening, but anytime you want to send you or your representative here to tell us your thoughts, one of my immediate thoughts when I saw that was, well, do we have a higher incidence of crime in multifamily as opposed to single-family detached? I don't know the answer to that question, but if that would sway my opinion on voting on things, if I knew that to be true, I don't know whether it is or not, I'd like to hear from them about that.
So I think the sheriff's department does get land use and zoning requests
That's
for
correct.
comment.
Yes.
I'm
They
not
get
sure
the
that-
pre-app,
I don't know if they're
invites to
getting
pre-apps.
the LDC amendments, are they?
They don't.
Okay.
No,
But staff can certainly ask for the comments on that one,
Yes.
that particular one.
Absolutely.
Okay, let's continue.
All right, continue, okay. So the next section is the nonconformities. This is, when we drafted the nonconforming sign section, we should have brought a statement from the restoration section into the nonconforming sign section. So it's being removed from the restoration section to the nonconforming sign section. Just a unintended consequence. Next section is 1300, concurrency and impact fees, section 1301, concurrency. It removes transportation concurrency as that was eliminated on 4/17 of 2013. It removes mentions of traffic study throughout, and it just removes a lot of the legacy language in the section. And then the last section is Appendix A definitions. We actually define the term hard copy site development placard. And that's it. So we're asking that you find, I know we have public comment, that you find the proposed ordinance amendments consistent with the Pasco County Comprehensive Plan and recommend approval to the Board of County Commissioners. I will work on the blood item and on the fence item. And this is going to the BCC for first reading on 11/15 at 1:30 in Dade City and for adoption on 12/6 at 1:30 in Newport Richey.
Okay. So, you want to make a motion?
No, we have someone here for a
You
comment.
have public
Oh, I'm
comment.
sorry, didn't know we did. Oh, okay.
Cynthia
Hiding
no
back
longer
there.
works for the, I know you may have thought she was a county employee 10 years ago, but she's not anymore.
That's what I was thinking.
I didn't even see her, she was.
I was hiding.
Behind Terry.
Good afternoon, my name is Cynthia Spidel, and I'm with Stearns Weaver, located at 401 East Jackson Street in Tampa, and I have been sworn. I'm an AICP certified planner with 17 years of planning experience, including my 11-year tenure here at Pasco, and thank you for the opportunity to comment. I'll keep it brief. I just wanted to thank Denise and David, first of all, for actively engaging the shareholder community and development community in this voluminous amendment to the Land Development Code. My comments are very specific to the proposed changes to Section 802 regarding tree removal and Section 1003 gates, fences, and walls. My colleague Jake Kramer has been actively working on the proposed language in Section 802 regarding tree removal with David Goldstein, but is unable to attend this hearing today. So on his behalf, I'm here to just state that he's continuing to review the language and will be actively engaged with the Farm Bureau to ensure that the look-back provisions proposed in the code do not interfere with the Right to Farm Act. We have not yet come to a resolution at this time, but we're getting closer. And he will continue to explore solutions and potentially bring that forward at the next hearing. With respect to Section 1003, the proposed language states that certain types of fences shall be prohibited in yards visible from collector and arterial roadways. Our concerns was with the term visible, and we would like to continue discussions with the team in order to establish a more measurable term that is not subject to interpretation. And with that, I thank you for the opportunity to comment.
Thank you.
Thank you.
Okay, so now you probably can make a motion.
Probably need some help on this.
For the
Make
record,
sure-
we have no one on WebEx to speak to this item.
All right.
And I would move to approve the ordinance, subject to staff revisiting the section on fences, walls, and gates to address styles of fences versus materials for fences, what constitutes adequate screening from the right-of-way,
Security.
and security. And I also,
I think they also wanted them to evaluate whether the gate should be included
yes.
in the
That-
prohibition. Is that
yes,
right?
And gates, and that we
Right.
look at other communities' ordinances with regard to the definition of family, specifically the term, the meaning of the term blood.
All right, so we have a motion. Do we have a second?
I'll second.
Okay, we have a motion and a second. Any further discussion? Hearing none. All in favor? Signify by saying aye. All opposed, like sign. Motion carries. Yeah, that was easy, John. Thank God David's
Told you
here.
you were going to answer all the questions today, David.
Most of those I expected. I did not expect the fight over what is blood, but
Actually, to be honest with you,
Oh, boy, I didn't
it's a
either.
gang out of East LA. Actually, it's a gang out of South Central LA.
I just figured it was, I know it when I see it, but
Yeah,
I get your
right.
point.
Blood in, blood out.
Need a motion to approve, sir? A motion to,
Adjourn.
Well,
Yeah.
Yeah, we're gonna adjourn, but it was funny, because as we were having that, I just kept thinking this, like, when you're kids and you become blood brothers and you,
Oh, yeah, right, exactly.
okay, well, are they related by blood now?
That's right. That's right.
Well, it's terms like that that keep lawyers in business.
That's right. We had a motion to adjourn. All in favor, signify by saying aye.
Aye.